Mr. DeBose is right. I am going to find in favor of the plaintiffs in this case. Obviously, we're turning over ownership of Futuristic Hub and Wildcraft, but
Last year in April of 2022, Brian Martin and his wife Holly Bone lost their lawsuit in Dallas, Texas. Brian filed an appeal for that judgment. Yesterday, on November 15, 2023, oral arguments were heard for this appeal. The following is a recording of the oral arguments at the 5th District Court of Appeals in Dallas, Texas. Results from this appeal shall be posted in 2024.
Good afternoon and welcome to the 5th District Court of Appeals. I hope you like our courtroom. I love this courtroom, so if you don't, sorry, I get to win on this one. I have the privilege and pleasure of serving with Justice Carlisle and Breedlove here today. Just housekeeping, y'all are familiar with our clock, our lights. So you have 20 minutes. The light's gonna show up at yellow at 3 minutes. Red, please stop. Each side gets to 20 minutes. You'll have rebuttal for 5. It'll turn yellow at 1, okay? I'm going to call the case of Holly Bone Martin et al. Versus David Tyler Moss et al. It's 0522-00439 CV. Counsel, would you please announce your presence?
My name is Susan Clouthier, and I represent the appellants Holly Bone Martin and Brian Martin.
Thank you.
Shelby White for the appellants.
Thank you. Okay, we have read your briefs and pertinent parts of the record, so counsel, if you'd like to approach. And I am going to start the clock this time. I missed it last time. You ready to proceed?
Yes, Your Honor. Thank you.
You may proceed.
May it please the court. Today I'd like to address 2 issues primarily, and then we can more time I can get into the other issues. First, the statute of repose having extinguished this entire cause of action prior to its filing. The reason I want to start with this rather than the preemption issue for Federal Copyright Act is this would resolve the cases a little more simply. So I figure we start here. If you'd like to do anything different, of course, you let me know. But this is an interesting fact pattern because, you know, where the statute of repose, as opposed to the statute of limitations, it actually can extinguish the suit before the filing of the suit. Where here, the original petition on its face and the evidence attached to the original petition of the appellees affirmatively, as a matter of law, establishes the dates of the transfers and establishes as a matter of law that the suit was extinguished prior to its filing. Where in most cases, when it's analyzed, it's done in the context of a summary judgment. We did not I was not part of the case, and that was not filed here. But as the court knows, jurisdictional issues can be decided and raised at any time. So I did want to bring a few things to the court's attention. This is strictly out of the original petition, which is found in the first supplemental volume of the clerk's record. And I can give you the exact page if you, it's 193, I believe, is where we find this. And so in the actual petition itself, in the factual stipulations, it says in June 2016, the LLC formation and the first alleged transfer was under number 34, fraudulent transfer 1. The judgment found that the judgment debtors Brian Martin, etc., were in partnership with judgment creditors regarding the video games YouTube channel. About 2 months after the judgment was entered, which would have been June, Brian Martin and his then wife, Chrissy Martin, formed Futuristic Hub LLC and started the brand new Futuristic Hub YouTube channel, and they attached the certificate of formation as Exhibit C to that. They state in the petition under paragraph 28, plaintiffs have convincing evidence that Brian Martin and Chrissy Martin own Futuristic YouTube channel and incorporated the LLC in the state of Texas approximately 2 months following the judgment. And here they state they began posting videos, they gained a significant following, and began earning significant revenue. And I just want to stop and mention why that statement is important in this case is because they started, you know, that means that all of the revenue that was dealt with later in the case began here.
So let's start taking this a little bit slower. Statute of repose is an affirmative defense, correct?
Correct.
Okay, so defendants have the burden to bring forward evidence of the first alleged transfer, and the creation of an LLC is not a transfer, right?
Well, in their petition, they
Well-
do allege that it was. So
No, well, they're alleging that, let me say it this way.
Okay.
Is it the contention then of appellants that the allegation in paragraph 28, I believe, of the petition that identifies the date that the LLC was created is sufficient evidence to support the affirmative defense of statute of repose?
That, along with paragraph 36 and 37, where it says that the animation style, voice acting, and subject matter of the videos posted on the Futuristic Hub YouTube channel are the same or substantially similar to the videos that were posted on the Video Games YouTube channel, which was the subject of the federal suit.
And where is the evidence in the record of what date that occurred?
In the petition, it states that forming that Futuristic Hub YouTube channel in June of 2016 was, and they do say, by forming the YouTube channel and continuing to produce the same content as the prior channel subject of the judgment, they committed and are continuing to commit a fraudulent transfer.
Okay, and then going back, so where is there evidence in the record of any of that occurred?
The evidence, it's primarily in what our position is that the judicial admissions and the pleading itself satisfy that it's as a matter of law, based on their own pleading. They're saying to the court, this is outside the statute of repose. Our first transfer was in June 2016. This is what we're saying. We're attaching the LLC's formation documents to the pleading, and therefore...
Are petitions evidence?
I wouldn't say petitions are evidence, but this is the statute of repose is a unique affirmative defense, because we're, unlike the limitations defense, where you develop that defense through trial, it can be cured by amending a pleading, because this actually extinguishes the suit prior to the filing. Therefore, it's like the suit never happened. So that actual lawsuit and the pleading itself is void on its face. So it's not, you kind of have to consolidate all of the case law and read it together to kind of get to this point. But, there's some case law out of the district court in Northern District of Texas talking about, once the statute of repose distinguished a claim under Tufta, amending a complaint would be futile.
What about the allegation of transfers that took place after that date? Are you suggesting that the statute of repose would extinguish the allegation of transfers? Let's say, for example, the allegation that payments were received or transfers were made in late 2018. Would those be extinguished as well?
Well, I believe because the suit was extinguished, the suit was it's not the claim, it's the entire suit. So
what's a case that articulates the statute of repose in that way, that other transfers would then also be extinguished, that we should look at?
Nathan v. Whittington, Texas Supreme Court case, it's 408 Southwest 3rd, 870, it's in our brief. That's where it talks about that it's strictly construed, it extinguishes the cause of action before filing the suit. And there is also case law that talks about that subsequent transfers and transferees of the same subject matter. This wouldn't be relevant necessarily here, because I believe that really all we have to look to is the face of the pleading. The suit should have been extinguished on the day of the filing, but the subsequent transfers of the same subject matter, which was what they alleged were videos that were the same or substantially the same as those that were on the Video Games channel, which was the subject of the federal lawsuit, which they then moved to Futuristic Hub, which then was again moved to Wildcraft, and then so on. But they were the same subject matter, but it's
a separate transfer. It's not the same transfer.
I agree that it's a separate transfer, but it's of the same subject matter. So case law states that if you're transferring the same subject matter, it goes back to the original date of the first transfer. But in this case, because of the fact that the pleading itself was deficient on its face, they did amend the pleading. So
what does the live pleading allege?
The live pleading took out the language saying that they had used the subject matter of the videos on the video games channel, and that was the subject of the first transfer. And instead, they said that the subject of the first transfer, that they did try to form the LLC for purposes of hiding assets. So it sort of said similar things, but it was a lot more vague. So I don't think it was as straightforward.
So considering only the amended petition, because obviously under pleading rules, we can't look at a petition that's been amended, right? So under the amended pleading, what is the contention that the statute of repose extinguishes the claim based on the fact that this is, again, an affirmative defense? What paragraph of the amended petition would we look at for that factual pleading?
I'd like to suggest, if you wouldn't mind, that I actually don't believe that the amended pleading had any effect at all, because of the fact that since the cause of action is distinguished before filing, that having an amended petition of an extinct cause of action or claim would actually have no effect and would be futile. There's a case out of the Northern District that does state that in Taylor versus Trevino, 569 F sub 3D 414. We did not cite that in the brief. I can file a post-submission letter if you'd like. But the pleading, I don't have the exact pleading in front of me, but it is in our brief. And I also would like to mention, for purposes of your question, in the the trial itself, the plaintiff's attorney opened with, Judge, this is the important date here that we need to really be paying attention to. The date is June 2016. This is when Brian started trying to transfer assets and hide assets from, and I don't remember the exact language, it's in our brief. So actually I have it right here. It's on page 10 of the 5th volume of the reporter's record. It was an opening statement. Another important date, Your Honor, is June 7th, 2016. That's the date that Brian Martin and Chrissy Morton formed Futuristichub LLC with the Texas Secretary of State. Why is that date important? Because, Your Honor, that was 2 months after the $18 million judgment of the federal court. So this is the beginning of Brian Martin attempting to protect his assets through videos. So that is also evidence that is pretty...
Arguments from the well are not evidence, right,
What they
counsel?
do, but I would say would be considered judicial admission for purposes of establishing the fact that this case, we're looking at, it's supposed to be construed extremely, extremely strict. The purpose of which is so that litigants are aware that at some point the time runs and that they can't be held liable for any kind of claim. And so it's being that it's so strictly construed, it bars the entire right, not just the remedy. So in order for that to be the case, I feel like we have to look at it in a little bit different light from a normal affirmative defense like statute of limitations or unclean hands or something like that, where you would be having to prove that in the context of the trial and presenting evidence. This is slightly different because it's actually jurisdictional. So the court did not have subject matter jurisdiction to even proceed. And as you know, courts have a duty to sua sponte, know and whether they have jurisdiction and check into that. So the moment the pleading was filed, the court, could have and should have probably noticed, okay, based on this pleading, this is not timely, the statute of repose applies, this should be dismissed.
Okay.
So, I'm not, I won't beat that up, but if you have any specific questions about any more of that. And then the second point I'd like to make is based on the Copyright Act and the federal preemption. This, I think a lot of the kind of where the rubber hits the road on this claim has to do with the fact that we're sort of, whether or not you construe the claim, the cause of action, as a federal cause of action under the Copyright Act, or whether it's the remedy or the what's being done. And so in this case, what we're not saying necessarily, we're definitely not saying that a state law tort claim falls under the Federal Copyright Act. But the kind of novel question in Texas is, can you involuntarily divest a copyright owner in state court of its copyright but through Texas law? And I suggested the answer would be no. under 17 USC 201E because that is a federal question. So
Can you distinguish the divorce division of the Futuristic Hub between the married parties where the copyright was actually given to one, so involuntary divested? Would that be involuntary divestment?
I don't believe that's the same thing because that, I believe the divorce decree was based on, you know, the parties splitting assets of there was no like transfer of the copyright. It wasn't like they said we are hereby, and it's this.
Well,
the
you use the term
copyright-
divesting, so this is a divestment. So.
Correct, and,
Chrissy was
and the
divested.
Copyright Act does require to actually have an involuntary divestment. There's very strict rules that have to apply, and it has to be in writing, and it has to be done in a way that it's very clear that they are actually signing over the rights to the copyright. And there was a case that we both, I believe, cited that had to do with a company that had actually sold its copyright and then later was divested of that right, and it's in the brief. But that's a different situation because that was actually done through the Copyright Act and followed the steps in the act that required what you have to do in order to actually transfer a copyright. It's not done through word of mouth. It's not done in a divorce decree. It has to be done in accordance with the Copyright Act, and according to the act, it also has to be done in federal court.
So I guess what I think Justice Goldstein is getting at, I think it's in the record that in 2019, in the divorce court, the divorce judge, the family court judge awarded Martin all duties, rights, title, interest, and copyrights, earnings past, present, and future to YouTube channel Futuristic Hub and Business, and so divested all of those copyrights pursuant to a state judge's order. Did the state judge have the authority and jurisdiction to award Martin those copyrights in that decree?
Well, I mean, if you were to look at the court's findings of fact in this case, while we're not conceding anything, they said Brian Martin had always owned the copyrights of
I'm
those
just asking
videos.
about whether or not the district court judge had the jurisdiction to award those copyrights to Martin in the divorce.
So hypothetically, assuming they were owned by Chrissy, whether they could have awarded them to him in the divorce decree. Is that the question?
I think that's part of the record.
Well, I think we're referring to the prior opinion out of this court.
Okay.
It's at 2022 Westlaw 484312, and that's part of the opinion.
I did read that, yes, Your Honor.
So that's where we're asking this question, because it would seem that even though there's different parties involved and different procedural postures relative to each party's interest, the state court judge is still making that determination, and it does not appear to be going through a federal judge and copyright proceeding.
But I wouldn't say that necessarily was involuntary. That could have been a voluntary decision between the marital parties. I was not a party to the divorce, so I'm not familiar with if that was an agreed divorce decree or whether they had a contested divorce on that issue.
But how would that change whether or not a district court judge has the authority to do so?
It's the authority to divest, involuntarily divest for the purpose of satisfying a judgment, not we're deciding, like in a divorce, the state court has a great deal of latitude of determining whose property is whose. That's not the same thing as saying, okay, you've got a judgment that is the third party, non-related to you, and we're going to satisfy that judgment by giving them your copyrighted material, your intellectual property that has been created by you and owned by you. So that's a distinction. So I would say that whether or not the divorce had any issues there, I don't know, but I don't think it would matter.
So it's the act of divesting someone of their intellectual property in order to satisfy a debt through a judgment.
Correct, and through collecting on a judgment. And case law is not settled in Texas on whether or not that can be done. And
Is it settled elsewhere?
kind of, appellees do cite to a case saying it's from the Minnesota Court of Appeals in 2015 in their brief, Sprinkler Warehouse, and they say that that's basically that would be acceptable there. I think we had cited to a case, I think they cited to one in Northern District of Oklahoma, but there's nothing Texas. It's really, it's a completely undeveloped issue here, and it's not even developed in the Fifth Circuit. I think that issue is 100% new and novel, but the issue of is it preempted, I think, is established as far as it's not been previously transferred in accordance with the very strict guidelines of the Copyright Act, so you cannot transfer it involuntarily pursuant to the Act without having the federal court construe the Act. And there was one mention in Appellee's brief. They say that 17 U.S.C. 201E is not controlling, explaining that it construes that statute as a per se taking by appropriation. But even if that were the case, and I'm not saying it is or it isn't, that's an interpretation of federal law, which would, again, belong in federal court. I'm about out of time, so I don't want to go over.
Any questions? Thank you, Counsel.
Thank you.
So, organized here.
Just let me know when you're ready to proceed.
Mystery Fund. All right. May it please the court. My name is Shelby White, and today I have the honor of representing the appellees in this case. Simply put, this case is about two things: money and fraud. We are owed money, and the Martins have been moving that money and hiding that money from us, so we can't collect. And ultimately, what the appellants are asking you to do is endorse an original wrong and prevent us from collecting money on that original wrong. First thing I want to talk about is the statute of repose. This is an argument we didn't brief necessarily, but I think it is important for the court to understand there is a waiver issue at play here under Trap 33. Yes, statute of limitations was raised in their answer, but they never actually put that before the trial court. So there is no motion before the trial court asking the trial court to rule. If you look at the reporter's record in volume 7, that is the first and only time you will see the word statute of limitations or repose mentioned. And it is it's close to the end, and the opposing counsel is questioning Mr. Keating about when these transfers happened, and then he says, well, isn't that outside the statute of repose? And the trial court says, that's a legal conclusion, that's not an appropriate question for him. And our trial counsel says, if he wants to argue about the statute of repose, he needs to file a motion or ask the court to do something about it. That never happens, and then if you look at the findings of fact and conclusions of law, which they did not object to, there is no finding for a statute of repose, whether it applies or not. There's nothing about it, and they didn't object to it. So we do have a potential waiver issue here, just right off the bat, that if they want to argue statute of repose, they haven't preserved the error. Second, I want to look at the dates that are actually at issue. They say, and I know the court is kind of already in tune with this, they say that June 7th, 2016, the creation of the LLC, that is the fraud. And that is not the fraud. You can create an LLC. The fraud occurs when he actually starts to transfer videos. And they have never put forth evidence of what date the videos were transferred. And that's part of the issue we've had throughout this trial is it's a fraud trial, and he keeps hiding things from us, and he keeps moving things around, and he keeps refusing to answer discovery. And so yes, we've had a lot of problems getting straight answers from any of them. And I think if you look at the way this case has proceeded, just in terms of fairness, we are looking at a federal court judgment at the end of 2016, and the case is up on appeal until the end of 2019. And so we can't really, my understanding is they did not file an appellate bond in that federal court judgment, but if we wanted to collect on that judgment while the appeal was pending, if the appeal was overturned, we would have had to pay that money back. So that's kind of a dangerous game to begin with, to try and go out and collect on this judgment while the federal appeal is pending until January of 2019. And when the opinion comes back in January of 2019, we start our post-judgment discovery again. We find out that he's been moving assets quite a bit. He's been moving money quite a bit. He's been moving videos quite a bit. And we timely file suit at that date. The other thing I think we need to keep in mind is that Tufta is not the only claim we filed. So the statute of repose, as far as they've argued, only applies to Tufta, and we have conversion claims, we have aiding and abetting, we have conspiracy, we have a bunch of other claims. And as Justice Breedlove has already mentioned, we have a bunch of other fraudulent transfers. There's the transfer of the house. There are transfers of multiple videos over a period of time. There's not just one transfer, and that one transfer is not the creation of the LLC. So 2016, for purposes of a fraudulent transfer date, is meaningless. That's not the only fraudulent transfer, and that's not when we allege the creation of the LLC is not what we are alleging to be the fraudulent transfer. As in terms of what trial counsel mentioned at the opening statement, when you look at that statement, what he's talking about is you can tell when Brian started to hatch his plan because he created the LLC, and you know, okay, he's got something in mind here. But in terms of us, in hindsight, we can see that. But at the time, we would have no reason to be looking for Secretary of State records for this, or to understand that it meant anything significant in terms of, oh no, your statute of limitations or your statute of repose is starting to kick in because of this creation. The second thing I want to talk about is in the reply brief for the statute of frauds, she mentions a letter that Holly sent, an email that Holly sent to opposing counsel claiming that she owned Futuristic Hub. That's also not indicative of a statute of repose, because if you look at what the findings of fact the trial court made in that case, the trial court said, A, that letter was, or that email was actually from Brian, and two, that he didn't transfer the videos at the time that Holly claimed that she owned the videos. And so what that letter is basically asking us to do is assume that a fraud happened when the trial court found that the transfer had not happened yet. The trial court found the transfer from Brian to Holly for the Futuristic Hub videos did not happen until their post-marital agreement, which was a month before we filed suit. And so if they want to rely on the letter as indicative of when we should have known that there was fraud occurring, the trial court already found that that email was not the fraudulent transfer, that Holly did, the videos had not been transferred to Holly at that time yet. The second thing I want to talk about is the copyright, assuming there are no more questions on statute of repose. First, I think the thing to keep in mind here, some of the cases that she cited to about the test are from the Fourth Circuit, and the Fifth Circuit has its very own specific Fifth Circuit test, which is the extra elements test, and so that's what we're bound by when we look at whether or not the Copyright Act applies. Second, what is this suit about? As I said earlier, the suit is about money and it is about fraud. The suit is not about videos. The suit is not about who owns these videos. The suit is not about whether someone is infringed on a copyright or whether someone is violating a license or who created this video or whether or not there is, co-owners of the video. This is just about you owe us money, you need to pay us the money, the videos produce money, therefore give us the money that the videos have produced. I already said that. The Fifth Circuit extra element test, when we look at that, we look at the cause of action and we see first whether it falls within the subject matter of copyright. And here, as I said, the cause of action is fraud and related fraud claims, so conversion, aiding, abetting, things like that. And all of these claims are about whether or not Brian is hiding money, whether or not Holly is hiding money. They are not about who owns the rights to these videos or what we should be doing with these videos in terms of copyright.
Is it an objective look at the cause of action? Or is it a subjective of sort of how it's pled and how the facts apply in this case?
So there is an element, I'm not sure I would consider it subjective or objective, but there is a consideration of, you don't just look at, this is what the cause of action requires. You do look at what's pled and how that is specific to this case. But as I've said, when you look at what we've pled, we're talking about money. We've always been talking about money this whole time. The second, and so I think even I think they've alleged that the cause of action falls within the subject matter of copyright. I think it doesn't really matter because we meet test element 2 anyways, but I would disagree with the fact that this suit falls under copyright to begin with, because this suit is a suit for fraud and is a suit for money damage, money that was owed that you have been moving around and hiding from us. The second part of the extra element test is to determine if the cause of action protects the rights that are equivalent to federal copyright acts. And as I said, this is a suit to recover money. When you look at what Tufta, what that cause of action is talking about, it says you need to have, in terms of the elements, you need to have a transfer made with the actual intent to hinder, delay, or defraud. And so neither of those are talking about your rights under copyright, your infringement of your rights, or anything related to that. And there is a case that I want to point this court to. that I don't believe that we cited, so I'll give you the citation. I can prepare a post-nut brief on it as well, or excuse me, a post-argument brief. Yes. Computer Management Assistance Company versus Robert F. DeCastro, Inc. It is 220 F. 3rd 396. It's from the Fifth Circuit in 2000. And the case is involving what is known as LUPTA, the Louisiana Unfair Trade Practices Act. But what they talk about under that case is similar to here. Fraud is an element of the claim. And what the court says is because a cause of action under LUPTA requires proof of fraud, misrepresentation, or other unethical conduct, we find that the relief it provides is not, quote, equivalent to that provided under the Copyright Act and thus is not preempted. So we have an extra element here, and that extra element is fraud. And once you have fraud, copyright really has nothing to do with fraud, and therefore we are outside of the Copyright Act. The second thing I want to talk about under the Copyright Act is to keep in mind what the court's goal is here, and it's just to preserve the status quo. The status quo is that the videos were under the Futuristichub YouTube channel, and that's all the court was really seeking to do, was keep those videos there, and by doing that, the only way to do that was to give control of the channel to the plaintiffs or to a receiver. Because we know that Brian and Holly are moving these videos around, they're transferring them to the Wildcraft channel, to other places, and so the court is trying to maintain the status quo so we can collect on our money.
Did the court do more than that?
No. If you would like to talk about damages, we can talk about damages.
Why don't we talk about damages?
All right, let's go there. First and foremost, I think the issue is that the plaintiffs, or excuse me, the defendants have come with unclean hands. I guess I should say, first we're talking about the value of the videos. And I believe that was part 2 of our damages arguments that were made, or their damages arguments were made, that there was no evidence of the value of the videos. And so first, defendants have come here with unclean hands. As I mentioned earlier, they refused to participate in post-judgment discovery. They refused to participate in discovery for this case to begin with. Brian's pleadings were struck because of that, and he had a default judgment as to liability.
But before getting into that detail, just to kind of organize the damages awards. So this particular lawsuit is not a lawsuit to enforce the judgment, though, is it? This is a separate fraudulent transfer, conspiracy, fraud, aiding and abetting claim. So
it's both, to answer your question. Or if,
it's a collection suit and
yes, if you look at the pleadings, there are actually 2 original filings. The first filing was a filing to domesticate the judgment.
Okay, walk me through that, because this was a judgment out of the Northern District of Texas.
So there's a judgment out of the Northern District of Texas, and so the first filing is just, we filed the federal court's judgment in state court to domesticate the judgment so we can collect.
Right, but does that have to follow the Uniform Enforcement of Foreign Judgment Act? Because it's not a foreign judgment, so you're just filing it so that the court knows that there's a judgment someplace and recognizes it.
And I think part of it was we had so many collection issues and so many places we were trying to track things down. But to kind of jump to the next step, what happens after that is a few months later we file a separate Tufta fraudulent, a separate claim, and the trial court has us consolidate those 2 actions under one cost number. And so to answer the question, yes, there is a domestication of the judgment, but there is a separate, independent fraud claim. And I guess now I've gotten a little bit off track. I didn't know if we were going somewhere with that or if we're just setting the stage. When we're talking about the double recovery that they've pled, it's not a double recovery because there are 2 separate things that we're recovering under. 1, the money we originally owed, and 2, there are new causes of action, there are new claims, and there are new things to recover. Holly is now a proponent of the fraud. The mother is now a proponent of the fraud.
Was the mother a party to this lawsuit?
She's not a party to the suit. They did undo the transaction, though. So what happens is mom gives money to Holly to purchase the house, and then Holly.
So the house transaction was undone?
I don't know that they unsold the house, so to speak, but that money was put back in the judgment, if that makes sense. She sold it for less value than it was worth, I think $100,000 less than what she purchased it for. And so the trial court found that to be a fraudulent transaction. And then my understanding is subsumed that into the money judgment, but I might need to revisit the judgment and double check myself on that. I think when we're looking at the double recovery, what they're trying to say is that we have both the videos and we have a money judgment, therefore That's two things to recompense the same wrong. And when you look at Tufta, what Tufta says is you can have the money and you can have equitable relief. You can have more than one. And I think the issue with the equitable relief, they try to make this claim that there's some inherent value to the videos, that we are now, as owners of the videos, we have X amount of money based on the video's value. And that's not what we have. We have the rights to collect on the revenue from those videos through YouTube.
But under Tufta, first you have your monetary damages and the equitable relief. Putting the equitable relief aside, what's the basis for the calculation of the monetary damages under Tufta?
So basically, one, we have the underlying judgment, so that is money.
Okay, that's separate. So
Yes.
It's a little confusing because you have a judgment. All you're saying is, hey, state court, I want you to be aware of this. There are no damages awarded. It's just an acknowledgement that this judgment of millions of dollars exists.
Yes.
Then you have causes of action for Tufta, civil conspiracy, aiding, abetting, conversion, and fraud.
Yes.
And the court awards damages for each cause of action. So taking Tufta, what is the basis for the monetary award of damages under Tufta?
That is how much money the channels are producing. And so
Hold on. The basis, and that's in the findings of fact, where the court makes a finding of the videos are making X amount of money per month, and so court awards as damages under Tufta X amount of money.
Yes, so we have Mr. Keating kind of multiply out the math. Holly testifies that the videos make $90,000 a month. They have an issue with that number, which I can address separately, but assuming that number is correct, Brandon takes the math and parses it out and says, you have X amount of money.
For how many months? So is it
He's starting.
Is it a Tufta award of if the videos are making so much per month, you get that much until the judgment is satisfied, or how does that work?
So I think that is a bit confusing. I think it would be until the judgment is satisfied.
But is that what the judgment says?
No. So the judgment says you have money damages, and then the judgment says, and that's why I'm parsing it as equitable relief and monetary relief. Monetary relief being you are entitled to this much money because you were owed this much money and it's been fraudulently moved around, and that's money you are entitled to. Under the federal court judgment, that's money we should have gotten, and you made fraudulent transfers to hide that money from us.
I know, but slow it down a little bit, because what you've said is these are separate causes of action and the damages awarded are unrelated to the underlying judgment. So again, the monetary damages under Tufta, if they're unrelated to the original judgment, what is the basis for the number that is provided for the monetary relief?
So my understanding is the judgment for the monetary relief, and I think to say it's totally separate from the underlying judgment is probably a stretch too far. What I mean is it is a separate cause of action, but what we are disputing, what the fight is about is that there is money, there is revenue coming in from those YouTube channels. We should be allowed to collect on it because we have an underlying judgment, and they are hiding it from us. And so when we're calculating the Tufta damages, we are looking at what money was coming in the AdSense revenue accounts, what money did Brian have that he has moved, or what money did Holly have that she has moved. And those are the fraud damages, is the money that came to Brian or came to Holly, and they moved it to hide it from us.
Okay, so is it the amount of money that was allegedly hidden from the date of the transfer to the date of trial?
Sorry, say that question again to make sure. I think I heard you right, and I want to say yes, but I want to double check myself.
Is the damages calculation the amount of money allegedly transferred from the date of transfer to the date of trial? Is that the premise for the calculation of damages?
Yes.
Okay, and is that number awarded under Tufta and fraud? Is it the same? Is it either or? I'm having some problems with understanding how the number is calculated.
Yes, so when you look at the judgment, it says for all the claims, from my memory,
so it's one number, so basically
one number for everything.
These 5 causes of action allow for damages of
4.5 as to Martin for Mr. Keating, 4.5 as to Martin for Mr. Moss.
And that
2.
number is the amount of money that was produced from the assets that were fraudulently transferred from the date of transfer to the date of trial.
Yes, that is our, I mean, again, we have to base it off of Holly's testimony, but that's our understanding of how much money should have been coming in or should have come, should have been coming in through AdSense revenue, through other.
If the money, if the allegation is, I'm not disputing the factual basis for the number.
Yes.
Let's say it's $4 million was revenue that was generated from the assets that were fraudulently transferred during that time period. Is that $4 million against Brian and Holly separately? So is it like an $8 million award, or is it a $4 million award that they're both liable for?
In terms of them both being liable, I'm not 100% sure because they're still married, and I think there's some joint and separate, but the way the judgment is written, to answer your question, 4.5 as to Martin owed to Mr. Keating, 4.5 from Martin owed to Mr. Moss, 2.8 owed from Holly to Mr. Keating, 2.8 owed from Holly
Okay,
to Mr.
so if you add all those up, that's 4, 8, 9, 10, 11. Is there a finding of fact that $13 million of revenue was generated from those assets during the time that they were allegedly fraudulently transferred to the date of trial? I mean, if you have a damage award of $13 million, is there evidence in the record that there was $13 million of revenue that was received from the fraudulently transferred assets?
Yes, I think there's evidence
Okay.
that 13 million, I don't think there's a finding in the judgment 13 million is the total and then parsing it out. I think we have the individual allotments, but yes, I do believe there's evidence in the record to support the total number.
That's my question.
It was part of this judgment because it only relates to the 5 claims that relate to the fraud, the TUFTA, not the collection of the monies that were from the federal district court judgment. That's not necessarily part of this judgment, but it appears that you're trying to collect that through this because you do have the YouTube channels are transferred to you and you have legal and equitable ownership of them. You have, you're legal and equitable owners of the videos, and it doesn't stop. So it's basically, they've lost all these videos forever, including Holly.
I am out of time, but if I
Please
finish,
answer,
okay.
yes, because this is part of the
And,
damage, because I'm trying to understand this
Yes.
as well.
So that's going to be 2-part. First, as we briefed, that is an equitable remedy. That is basically because we're playing whack-a-mole with these assets, basically, and so it is an equitable remedy, not necessarily to have more money, but to make sure the money we're entitled to collect stays where we can collect it. The second thing is that it is essentially moot for purposes of this case because YouTube has shut down those channels, and so they are not generating any revenue anymore.
Okay, but I think part of that question was, is that in satisfaction of the federal court judgment that you've domesticated? And so that's the question.
Yes. Yes.
So Holly, who had nothing to do with the federal court judgment, because of the manner in which this judgment damages are awarded, is helping to satisfy the $18 million judgment from federal court, correct?
Holly has her own fraud is the issue, sir.
That fraud is a different thing, that she was independently on this, which is the $2.8 million that she's responsible for.
Yes.
It doesn't automatically make her responsible for the payment of the $18 million.
No,
Correct?
Yes.
Okay.
But if you look at the way the judgment is set up as to ownership of the channels, everyone always found that Brian was the owner of all the Futuristichub channels. He tried to fraudulently transfer them to Holly, but these had never been Holly's videos, if that makes sense. And if there's anything damages-wise that you want me to address in a post-submission brief, I'm happy to do that.
One moment.
So again, for purposes of, because you domesticated, you consolidated the two, is this judgment that we have here also in satisfaction for purposes of satisfying the $18 million federal court judgment? Even though it doesn't say that, but.
That is how I would understand it, yes, is that it should, the money we collect should also satisfy the federal court judgment to a certain extent.
Okay, so they were consolidated, but doesn't appear to be in here as far as that, for that purpose.
And if it's not in there, then it's not in there, and if
I'm just,
It's separate.
I didn't read it that way, but I just want to make clear that that's, from your perspective, that's what's happening, is that 18 million will be satisfied from this judgment and the ownership interest that you have in the videos and the channels.
yes, because the fraudulent transfer, the way we are a creditor is that underlying judgment, if that makes sense.
So you're saying it's a factual, the fact of the other judgment partially is a factual predicate for the
Yes.
elements of these claims here.
For us to be a creditor under Tufta, that's how we became a creditor, is we have the underlying judgment. And so when we get this money, it does, to some degree, satisfy the underlying judgment, but there's also separate independent frauds that have happened after that, and so, in addition to that. That makes sense.
Thank you. Anything further? Okay, thank you.
Sorry.
That's okay. You ready to proceed?
Yes, Your Honor, thank you. I'd like to address a couple of points on what you were just discussing with my colleague here. In our brief, we do cite to the part of the record where they do discuss the damages model, and they don't do it based on when they allege the first fraud as of what she's stating as it occurred post marriage. But the damages model begins in 2016 and then goes through the date, I believe the date of trial. So the way they calculated it was based on Holly's kind of wavering testimony of saying, I think my channel makes about 80 to 100,000. And in the brief, they did mention that unchallenged testimony of someone believing about value can be used as evidence. But they actually had an exhibit that they admitted at trial, Exhibit 46, that shows the actual transfers and the amount of money that was made monthly. And if you go through, I mean, I just kind of noted, like June 2019, they made 21,000, July, they made 31,000, August 28,000, and it goes on. None of them were anywhere near 90. So I think there's kind of two issues as far as that's concerned. Is one, that the model assumes the transfer occurred in 2016, which we can't have it both ways. It either did, and it's the statute of repose, extinguished the suit, or the first transfer was much, much later, and they can only collect on the fraudulent transfers that occurred. So if there were no transfers prior to 2019, there wouldn't be any damages prior to 2019. And I think it would be an improper
what about
reading.
the argument that there was never a summary judgment or some other motion filed with the court to raise the statute of repose? That's essentially been waived.
I agree that if I had been trying this case, I would have taken that route. I think that would have been cleaner. But it is very well settled. The jurisdictional, subject matter jurisdiction issues cannot be waived as a matter of law. So this, I think, is one of those odd affirmative defenses that falls under the subject matter jurisdiction where the court cannot proceed. Everything that happens after jurisdiction has been terminated is then void.
It's your contention then that as an affirmative defense, it doesn't have to be raised at trial, it doesn't have to be raised pre-trial, it can be raised for the first time on appeal, the statute of repose?
I am suggesting that based on the case law that came out of the Texas Supreme Court saying that it's jurisdictional.
Did the Supreme Court say that it does not need to be raised at the trial court level and be raised on appeal?
That was not the actual issues before the court in that particular case, so that did not come up. But there are other Supreme Court cases that are very clear that jurisdictional issues can be raised at any time and cannot be waived as a matter of.
Do you have a case in which it stands for the proposition that the statute of repose may be raised for the first time on appeal?
I don't think it's ever been done before, so no. But I think that if you were to read the case, the Nathan B. Whittington case, in connection and consolidating those with the other cases that talk about jurisdiction in general, it cannot be jurisdiction, subject matter jurisdiction particularly cannot be waived and can be raised at any point whether it be in trial level or appellate level. I do agree that that might have been procedurally more proper, but that doesn't prohibit us from waiving it in this, or raising it here. I did want to mention about the channels. You know, the fact that the YouTube shut down the channels, I don't think is relevant to the inquiry about the value of the videos. The videos were very valuable when they were being posted, and every time they moved them, the last one being, I think, Wild MC, it didn't take long before they started getting revenue from the same videos on the next channel. It's like there's a connection though between Holly and or Brian and these videos. So these videos appearing on a third party's YouTube channel probably wouldn't produce much revenue, but the videos do have quite a bit of value because they would like them back so that they can post them on their own, you know, channel and continue to make money to support themselves and live, because this is their way of supporting themselves and eating, and you know, this is their lifestyle. You know, that I do believe that would be a double recovery, because if they're continuing to, if they have the ability to produce income, it doesn't make them valueless just because they're not producing income right now. I'm out of time unless there's any questions.
No, thank you.
Okay.
This concludes oral argument. Your case is now submitted, and an opinion will be issued in due course. Thank you all so very much for the great briefing and oral argument and answering the questions.
All right.